everyone, and thank you again for joining our webinar today on Justice Adapting the British Columbia Courts. As COVID-19 events continue to unfold, LexisNexis Canada is working to support the legal community by providing free legal news, analysis, and other key resources specifically geared to support your decision-making and counsel on COVID-19 matters. The LexisNexis Coronavirus landing page provides a document kit that can be downloaded for free. Existing Lexis Practice Advisor customers can access this information within the product through the COVID-19 pod. Access this content anytime at lexisnexis.ca/COVID-19. Today's webinar will now begin. And with that, I would like to introduce the moderator, Felix Evans, and I will start the camera view right now.
Thanks, Alex, and good afternoon, everyone. My name is Felix Evans, and I'm the moderator for today's panel discussion. Welcome again to the COVID-19 Justice Adapting webinar series. This webinar is part of a series of discussions LexisNexis is presenting across Canada to bring the legal community together in sharing updates and information about how lawyers, the law societies, and the courts are adapting to the pandemic. We have 1 hour, so this will be a brief introduction. Today, we're very fortunate to have with us on our panel justices from the 3 levels of British Columbia courts to share their experiences and insights. Joining us today are the Honourable Chief Justice Robert J. Bauman of the Court of Appeal, the Honourable Chief Justice Christopher E. Hinkson of the Supreme Court, and the Honourable Chief Judge Melissa Gillespie of the Provincial Court. I'm certain everyone listening already recognizes the unprecedented impact this pandemic has had on our justice system. We also recognize that the situation is changing rapidly and that the information we have is in flux. We believe that open lines of communication within our community are key to ensuring the justice system and its participants remain resilient and adaptive to the challenges ahead. And we therefore greatly appreciate the panelists taking the time to join us today. And I would extend our very sincere thanks from myself, from Alex, from everyone at LexisNexis and the company as a whole. The format of our panel discussion will take the form of a question I will ask to the panel, and then invite each justice to weigh in on that issue. A side note for any lawyers in the audience, this webinar is accredited for 1 hour of CPD credit, and you can claim this through the BC Law Society. The course is already pre-created, and it is entitled Webinar:"Justice Adapting the British Columbia Courts." So with that, I will start with our first question, which will go initially to Chief Justice Bauman. And the first question is, what is your general experience since the start of COVID-19 crisis for your level of court?
Thank you, Felix. Before I turn to that, I just want to thank LexisNexis for facilitating this webinar. I'm told that there's over 2,000 registrants out there watching this, which is an absolutely incredible example of what technology today can accommodate in the way of communication in a situation where otherwise we would be mute. So thank you, and thank Zoom for the technology. Let me deal with it from an internal perspective and from an external perspective as well. But let me just make an overarching observation. And oddly enough, although we have been apart and maintaining distance as required by the health officers, oddly enough, the pandemic, in my experience, has brought me much closer together with my team, my leadership team, and with my colleagues on the bench. And that's been a very positive development and surprised me as well. We, of course, internally have been busy trying to ensure that the Court of Appeal is up and running in as normal a fashion as possible. And in that regard, don't let me ignore the fact that the challenges the Court of Appeal faces as an appellate court are considerably different, considerably less than the challenges that my two colleagues, whom you're going to hear from in a moment, experience in their courts. Internally, I've had an extremely positive response from the court. The judges are expressing enthusiasm to try new things, and they are trying new things, whatever it takes to deliver justice in these changed circumstances. Contrary to popular belief, the judges are not being dragged unwillingly into the 21st century. We're there and we're prepared to try new things to bring justice to British Columbians. Our staff, I underline, have been working tirelessly exploring various enterprise options. We are, as you know, going back to, quote, normal operations via Zoom starting on May 4th, hearing all scheduled appeals in that fashion, as well as our full chambers applications by way of teleconference. Our registry staff, who I have to congratulate as well, have been in every day, working every day, trying to accommodate their procedures to receive documents in new ways. Externally, we've been getting some mixed messages. We've been prompted by lawyers, and I thank them for that, to up our game and to explore new technology so that the system doesn't shut down. At the same time, we've had some resistance from the legal profession and others as to the use of new technology. So it's been an interesting tension there. However, I'm pleased to say that the lawyers and the litigants that are coming to us in the far majority embrace the technology and endorse and support our efforts to change things up. Again, we've had, I think, disappointingly negative commentary in some areas of the press and other places, suggesting that judges are challenged by this kind of predicament, and that they are in unfamiliar territory and not used to addressing change of this sort. Of course, we're challenged, just like everybody else. But the fact is, I'm extremely proud of the way we are responding and the speed with which we're responding to the very significant challenges that the courts are facing with COVID-19. We're still, even before we get back to business as normal on Monday, and I say normal in quotes, we've still been publishing decisions. We've still been hearing cases in the last 4 or 5 weeks. We've still been hearing applications in chambers. Tomorrow, we're issuing 9 appeal judgments, one of the busiest days in judgment rendering that I've ever seen in my experience on the court. So the business of the court has been continuing. Judges are enthusiastically embracing the opportunities the crisis offers us, and it does offer opportunities, as been observed by many people. And our staff have been doing fantastic service and diligent service to British Columbians. Those are my general comments. Thanks very much.
Thank you so much, Chief Justice Bauman. And I'll pose this question next to Chief Justice Hinkson, if you will, please. Thank you.
Well, thanks, Felix. As Chief Justice Bauman indicated, the work in the Supreme Court differs considerably from the work in the Court of Appeal, in that the Court of Appeal can work from written record for the most part, whereas in the Supreme Court, we have the challenges of dealing with live witnesses, and we have been experimenting and trying new and different ways of dealing with the work that we do, but we've run into some very practical problems. For example, the court clerk's station in most courts is within 6 feet of the judge's station. And the court clerks are largely immovable because of the equipment that they have surrounding them. It's a very practical problem that has hamstrung us to some extent in even conducting video hearings because the judge and the clerk are so close together. We've not been able to do jury trials at all because we can't put jurors too close to each other because of the health officers' recommendations and edicts. We have tried a variety of initiatives, and I have to say that I have judges in my court who are more creative than I had expected, and I'm having to rein some of them in terms of what they'd like to try and do. We offered, for example, to do a criminal sentencing this week by video, and we learned that all three of the criminal defense counsel don't own laptops. Now, it's a real challenge to try and do a video hearing when you can't communicate with the people you want in the hearing. We have a limited number of video machines and equipment. We have asked for some years now for the provincial government to assist us with funding less antiquated and a greater number of equipment. That has not happened to date, but I'm pleased to say that the Attorney General's ministry seemed quite willing at present to address that problem. And so if some good comes in that sense from COVID-19, the litigants in British Columbia and the Supreme Court will be the beneficiaries. And it's not just the criminal defense bar who are challenged by technology. There are a number of senior counsel who are very uncomfortable with the prospect of anything other than the traditional hearing process, where lawyers stand in front of a judge and make their submissions. We have continued to try and expand the work that we've been doing because the view of the judges in my court is that we have to do as much as we can, as often as we can, to try and avoid what's certain to be a backlog immediately when we can return to a more normal practice. We have offered initially hearing of urgent matters only. We then expanded that to non-urgent matters which had been expecting to have a hearing that was canceled because of our suspension of our normal activities. We have recently expanded to written submission hearings, but it was necessary in order for us to do that to have the assistance of the provincial government in legislating a means by which we can avoid the practical results of some of the rules of court, which are rules that are promulgated by the Attorney General. And we needed the assistance of government, which they willingly and quickly provided to us so that we could do some written hearings. We're starting somewhat slowly because we're only hearing one issue on the hearing and telephone conferences we've been conducting. But that's only so that we can get started. I have judges who are chomping at the bit to do more than they're presently capable of doing given the restrictions we have. And the only other good thing that will come of this, hopefully, is that the reserve lists of judges who have judgments that they're waiting to release will hopefully shorten when they're not distracted by other activities. So that's in general what we've been doing.
Thank you so much, Chief Justice Hinkson. And the same question, please, to Chief Judge Gillespie around your general experience for your court level.
I can certainly say that for the provincial court, we have been challenged in terms of a number of the operations that we have. We have court locations, both in terms of regular courts that sit or circuit courts that service over 80 places in the province of British Columbia. The challenges that we've had initially in respect of that was that when confronted with the need to somehow develop a plan to keep public, court staff, lawyers, accused, judges safe, and yet provide access to the court for the most urgent matters was very challenging. We had to approach that by minimizing the risk of transmission of the virus and yet move to a virtual access really for all of our court matters, which is challenging for a number of reasons given a type of technology that historically we've had, as well as the bandwidth that's been available. And of course, you can imagine when so many people are coming online, working from home and remotely, it increasingly challenges that bandwidth. Nonetheless, we developed a plan to conduct virtual hearings in our most urgent matters. We have done that in our family division, in CFCSA matters, and in our bail matters as well. And we are in the process, we have used primarily telephone access. And it is really my view that as we move through this, the movement to a more sustainable platform, including video conferencing, is necessary to make durable and enduring changes that will change the way in which we can conduct much of the work that we do in relation to a lot of our remand matters, bail matters, and in the service to remote communities. So there have been certainly some positives there in terms of meeting those challenges. We also continue to look at ways to recover the work that we were doing. And as a consequence, and I should say a lot of work by a number of people within my court and outside of the court as well, we have released our most recent notice to the profession yesterday, in which we describe how it is we will be recovering much of our work in pretrial conferences, family case conferences, and small claims conferences. So we will be recovering some of our non-urgent work. In addition to that, we are also launching a pretrial conference process for criminal matters, in which we will first try to resolve criminal files, by proactively engaging with the parties. And if resolution cannot be achieved in that manner, we will look to managing the development of how the case will proceed in court through vigorous case management, encouraging counsel to identify the issues, look at possible admissions, and think about ways in which we can look at the amount of court time that is actually required for evidence to be taken, recognizing that while we are still in this pandemic situation and social distancing is required, as Chief Justice Hinkson indicated, the setup of our courtrooms is quite challenging, particularly in some locations. And we're also actively working with government to try to engage in a process to create safeguards within court locations so that physical distancing can be maintained, as well as other types of innovations, for example, plexiglass to encourage the safety of all court participants, and to limit the number of people who are at court at one given time. I should say that from my experience, there has been an unprecedented level of collaboration amongst all participants, including lawyers, members of government, but in addition to that, I would say the CBA, the Court Services Branch, and a tremendous amount of work done to manage and increase the bandwidth in what has become a very challenging time, but certainly more work needs to be done to accommodate what is an unprecedented amount of demand on that system as we move forward. Our court is also looking at expanding the work that we can do using video conferencing. We intend to use that exclusively for the pretrial conferences, and where possible move to use that for case conferencing in small claims and family case conferences, recognizing of course that many self-represented litigants are also challenged in terms of their access to available technology, for example. I would say that to a person, the judges of my court have been extremely resilient, very interested in embracing technology and providing access to justice for people in British Columbia in these very difficult times. Conducting telephone hearings are sometimes very complicated, particularly in urgent family matters. And there has been, as I say, an unprecedented willingness on the part of judges of my court to embrace this work to deliver access in these challenging times. And in addition to that, also conducting bail hearings, and I certainly commend counsel who've been involved in the patience that all have shown in terms of conducting bail hearings when sometimes the technology has been challenging, and the ongoing work of those in court services and corrections to maintain linkage during these periods of time. Much will continue to be done, and we will continue to take steps to accommodate self-represented litigants, lawyers working from home. We've done many things, including allowing applications to be made without the necessity of having affidavit material attached to that, and managing those oaths by virtue of connection of the telephone hearings. And we are moving towards using alternative methods to recover some of the other work, as I've indicated, that we're doing. And great appreciation to the court staff as well, who have assisted us, and the support of the other chiefs as well during this period of time. We have certainly, I have had the benefit of great input and assistance from the other chief justices as well, and I'm grateful for that.
Thank you so much, Chief Justice Gillespie. The next question I think has already been touched on to some extent. All of the justices have talked about technology, but if we could just quickly have your thoughts on whether there were any measures for virtual hearings already in place in some circumstances or areas, or were there any projects already in progress to offer this kind of technology for hearings in the future? And that question, I think, can go first to Chief Justice Hinkson, please.
Sure. Over the course of 2019, our court actively participated in the development of court digital transformation strategy, which aimed to bring a web-based virtual hearing system online over the coming 3 to 4 years. We're now rushing to try and adapt that so it can be used earlier. But each time we take a step forward, we find there are unanticipated issues that have to be addressed. So it isn't going to happen overnight, but we have been involved in that process for some time. Not only the judges, but our masters and court staff, counsel at the court, have all been trying to participate in bringing forward the technology that will assist the public to have easier and greater access to the courts. By way of example, our masters, and there are 13 of them, roam around the province to the various registries where we have sittings. And they conduct a number of chambers application hearings. We've found that they're traveling so much that they're not as productive as they would like to be. And in fact, the initiative came from the masters themselves. We proposed to the provincial government before the COVID crisis began that they save money on the master's travel costs and put it into video equipment so that we can conduct more hearings from the home registries of the masters. Now, that said, I'm not in favor of eliminating appearances by masters or judges in some of the smaller communities. The litigants in those areas are as entitled to the litigants in the larger areas to actually see the person who is administering justice in their particular case. So it's a bit of a balancing proposition. But I think from my discussions with the bar in some of the smaller communities, they'd rather have video than nothing at all. And so we're endeavoring to move forward with the video hearings. But as I said earlier, We have equipment challenges, and Chief Judge Gillespie talked about bandwidth issues, those kinds of things that until we start using the equipment, we're not aware of necessarily, or we haven't appreciated the magnitude of those challenges. But we have been working for a number of years. For example, we've had e-filings available for the past 10 years. We've found that many litigants, in particular self-represented litigants, are uncomfortable or incapable of e-filing. I was told this morning that our e-orders are keeping pace with what we saw before the crisis began. So there is use of that type of technology already, has been for some time. And the challenge for us is to try and expand its use as quickly as we can.
Thank you, Chief Justice. And the same question to Chief Judge Gillespie, please.
I'll avoid the rookie mistake by unmuting myself. The measures in place for virtual hearings, we've worked for quite some time in offering video hearings on weekends. We have a bail project and a virtual bail center that we have in operation, our Justice Center. So that has been in place for a number of years, and we hear bail hearings across the province, both by telephone, but actually by video as well. And I would say our experiences in the Justice Center have positioned us well for at least understanding on an initial basis what some of the issues were that we would face. Over the last 2 years, we've also worked quite closely with Crown and Defense Counsel, Legal Aid, in developing what was transforming what was once a process on the weekends where police approved and then conducted the bail hearings, to having Crown Counsel approve, assess the police investigations and the charges, determine whether or not and which charges to lay, and then conduct bail hearings. As a result of that, we were able to create courts on the weekend, virtual courts, where Crown would appear and conduct the bail hearing, and every accused person in the province had access to duty counsel, which is not something that historically occurred when police were conducting the hearings, because those hearings occurred between 8 a.m. in the morning and 11 p.m. in the evening. So there was a great degree of collaboration already amongst the Crown Duty Counsel, Court Services Branch, to create that possibility. And in fact, our Justice Center became a virtual registry about this time last year, when Court Services Branch took on the operations of the Justice Center. So a lot of the work that we have been doing remotely was certainly pioneered in the context of the Justice Center, and that's been very helpful for us. We also, during the week when we were providing pre-COVID periods, had a program called Have a Judge, Need a Judge, essentially where if you needed a judge to take some of the matters in certain locations, for example, if you had a judge in Surrey whose matters had gone down for that day, they were able to assist in other locations across the province by appearing by video and hearing video matters, for example, also hearing or presiding over case conferences in other locations as well. So we've certainly had that kind of assistance that we've contemplated and had in place for a number of years as well. We've been working over a number of years with Court Services Branch to improve video conferencing capability and attempting to ensure that we've got better units in place. Over the years, we also worked towards developing a system where we were transporting fewer people from correctional centers to courts for bail hearings. But of course, that work has now been accelerated greatly as we are no longer transporting anyone to courthouses for bail hearings. They're appearing at local detachments or at correctional centers. Court Services Online certainly has helped us view documents to be filed electronically and also viewed. And in addition to that, through this process, we've been accepting filings by email, and we have been working to increase that as well. And we also fortunately had just launched a process within our court scheduling model that permits judges to view all of the court files that are on their court list for the day through our court scheduling model, which has enhanced the ability of judges to work remotely and still be able to access information from court files. And a tremendous amount of work was done both in terms of court service, making sure, court services branch making sure that those files were electronically scanned, and also internally with our technology group to make sure that judges had the technology to make that happen. So we are well served by that, and but we continue to sort of push from there into a new and even more virtual world, but at least have those tools to work with.
Thank you, Chief Judge Gillespie. And the same question finally to Chief Justice Bauman, again around whether there were already any measures in place for virtual hearings and other kinds of technology developments, or whether that process is perhaps accelerated but was already underway.
We did not have measures in place for virtual hearings. We've been receptive to that concept for a number of years. We have been using video conferencing in a limited way. That's not a virtual hearing, as you can appreciate. And we've been using telephone conferencing for many years as an exception to the rule. And again, I don't see that as a very necessarily desirable way of hearing from people remotely. We, however, are receptive to this technology, but critical to it is an effective electronic appeal process, including enhanced e-filing and the ability to manage documents once they have been filed electronically. That's absolutely critical, and that may well be the legacy of the pandemic to our court in particular. We've had e-filing in place for many years. The uptake of it has increased every year, even with non-lawyer litigants. It's critical, I think, going forward that we have the ability to work electronically, not necessarily always in a virtual setting. In the Court of Appeal, at least, we will never not need the in-person court appearance in which the advocates can exercise the ability to persuade that's so critical to an effective appeal jurisdiction. We've been making funding requests with the provincial government for many years to enhance some of these facilities. It's been slow in coming, and we hope that the occasion of this tragedy will accelerate the electronic aspects of our ability to respond to e-filing and managing files after they've crossed the counter, as it were, in the registry. But as I say, we're hoping that that process will be accelerated. And indeed, we're seeing, I take Chief Justice Hinkson's point that not all litigants are familiar with or able to access the internet and electronic applications, but we're seeing increasingly a high percentage of users, including non-lawyer users of our system, demanding that they have the ability to approach us electronically by notice of appeal, etc. So we're encouraged in that regard as well.
Thank you so much, Chief Justice Bauman. And next, we move on to a slightly more a specific question around the court rules. And this question in particular is whether any court rules have been modified. If so, which ones? And of those changes that were implemented, how much of this was an exercise of inherent discretion, or how many of those changes were put in writing in notices to the professional regulations? And I think related to that was the another question, which is how is that information made available to the public and the legal community? And I'll pose this question first to Chief Judge Gillespie, please.
We've certainly been challenged by some of the rules that are in place. I can say that, for example, with respect to traffic matters, which are presently suspended, the Offence Act is not the most progressive piece of legislation, does not presently, within the four corners of the legislation, for example, permit disputants to appear virtually. So that is certainly, as we try to recover that work, there are issues with respect to that. We also, some of the criminal code matters with respect to warrants, search warrants, etc. The telewarrant provisions require impracticability in these particular set of circumstances, given what we understood about the pandemic and the transmission of the virus in particular, and the fact that face-to-face contact was not something that should occur to prevent transmission of the virus. And noting, of course, that we were in a state of emergency provincially, we moved to engage telewarrant only applications for those applications that were amenable to that, and discouraged otherwise face-to-face applications. We've also been, I think, quite explicit in terms of the information that we've placed in our notice to the profession and the public. We've tried to set out in one document the matters that are being heard, the manner in which they are being heard, the matters that are suspended, and the process related to having hearings in the particular divisions of our court. We have certainly created a roadmap for that, and it's been an ongoing process of change with respect to that as we're attempting to recover some of our operations as we move forward, and of course experience similar challenges around technology and the absence of reliable technology in the context of our hearings. We've also, because we service so many different people across the province, and many of those individuals are self-represented litigants, we recognize that even as we move towards greater technological advancements, in order to provide meaningful access to justice for people in British Columbia, there are many people in British Columbia who do not have access, for example, to internet on an ongoing basis. They don't have data plans in their phone that would permit them to appear virtually. So we need to be mindful of that as we move towards creating different and better opportunities for individuals. And we look to things, for example, as simple as maybe creating public places in the future where people can access private rooms for hearings if that's possible, and greater internet accessibility publicly for people. We also, I would say, how do we make, I think you've moved questions 3 and 4 together, but how do we make that information to the public, available to the public and the legal community at large? Initially daily and now weekly, I've hosted meetings with a broad cross-section group. Membership includes, for example, Crown Counsel, Corrections, Court Services Branch, Defense Counsel, Courthouse Libraries, Executive Director, Legal Aid, representation from certain family groups, from Indigenous communities, CDA. Those only name, I think, some of the people who attend these weekly conference calls. We have updates from various groups to assist us in terms of understanding what some of the issues are that are arising. And we have discussed how best to assist in recovering some of the work of the court, and certainly identified what some of the impediments might be. And for example, we've been able to, through the assistance of Legal Aid, move to pretrial conferencing on all of our criminal matters that are not summary proceedings matters. So virtually the bulk of all of our criminal matters to ensure that we're able to bring those to court. With respect to other avenues, we do have a public-facing website, and we have a particular page that deals with COVID-related issues. We place our notices to the profession on there, as well as any other notices that impact the public. We have a Twitter account, which is active and receives information from the public. We publish e-news articles in relation to the circumstance that we find ourselves in. We've published frequently our FAQs, frequently asked questions, to assist people who are coming to court in these new and difficult times. And we send information to media and legal groups to assist in terms of getting that information out. We've also increased the use of our high-profile judgment policy to post written decisions on COVID issues on our website immediately. And this ensures that the public can have access to those. I will say that there is a whole area of the law that is developed, particularly in relation to bail matters and urgent family applications as a result of the COVID circumstance. So those are some of the things we've been doing.
Thank you, Chief Judge Gillespie. And the same question around modification of court rules and how that information has become available to Chief Justice Bauman, please.
Thanks, Felix. On March 17th, we suspended court rule-based filing requirements, the timing of those. We recognized immediately that the pressure of a filing requirement on litigants and users of the system would be an added pressure in an already difficult situation. So we thought relieving that particular pressure was very important from the outset. And we've done that, and we've extended it, as you know, I believe, until the end of May. We also made submissions to government informally to encourage government to look at statute-based limitation periods, and government was already in the process of doing that, and as you know, came through with legislation that affects that as well. We used the power in our rules to abate these timelines, as well as the inherent jurisdiction of the court to manage its docket. But we thought it was very important. We communicated that. Now, remember, my colleague, Chief Judge Gillespie, her court is extremely sophisticated in communicating. Us, not quite as much, but we're working with 2 legal counsel and 1 registrar who are not professional media savvy communicators, although they're learning very quickly. But with that kind of support staff, I think we've been communicating very well. Through our web site, we have all of the announcements have been made in a timely fashion, in detailed fashion on the website. We've been doing email blasts to recipients of our annual report, which is broadly circulated. We also do an email blast to the accredited media list, which is very effective in getting the word out. One thing the pandemic has demonstrated to us, and I think we already knew it, but it just underlines the need for communication, transparent, frequent communication with the bar, with the public generally, and with government is critical in a situation like this. In my view, you can't communicate too much. So that's what we've been doing. We're hopeful that the message has been getting out. We're also very appreciative of the CBA and the Law Society. They will take anything we want to publish and push it out through their system as well. And from that perspective, it reaches the profession very quickly and very thoroughly. Those are the avenues we've been pursuing.
Thank you, Chief Justice Bauman. And the same question to Chief Justice Hinkson, please.
Sure. I'm going to bore you with a little bit of history first. The rules of the Supreme Court in British Columbia, both the family and the civil rules, actually aren't the rules of the court. They apply to the court. But as a result of the decision of the Supreme Court of Canada in the Thrasher case in 1872, the rules are those of the Attorney General. The Attorney General often takes advice from the Rules Committee, but not always. And so we work within the rules, and we have limited ability to override the rules of court. There are some provisions which allow us, for example, to abridge time, but for many matters, it's necessary for the attorney or the government to effect rule changes. And as I mentioned earlier, we did ask for one change to allow us to process hearings in writing exclusively. But to do that, we had to obtain the government's suspension of a couple of the rules. Otherwise, we couldn't proceed in that fashion. And as I mentioned earlier, the government acted quickly to accede to our request. The government has addressed a number of limitation provisions, and like so many steps, it's had some adverse consequences that I don't think were anticipated. For many of the matters that can often proceed by desk order, the suspension of the time requirements has put us in a position where we can't rely on the default if something isn't filed within the required period of time to allow us to proceed by way of desk order. So we're struggling with how we can do that. And so far, we've not come up with a solution as to how we can avoid the consequences of the suspension of the various limitation provisions that normally exist in a variety of rules and other pieces of legislation. In terms of our communication with the public and with the media, we rely on our website to a great extent. We have issued some press releases recently. I'm not sure how enthusiastically the press want to report what's going on in the Supreme Court to the wider public. We do rely on the Canadian Bar Association and on the Law Society, as Chief Justice Bauman mentioned. I did want to say something about the media because I understand some are listening. It's important that we recognize the open court principle in all of what we do. And with the use of technology and limited bandwidths and so on, we have to be cognizant of the fact that the media are entitled to understand the proceedings that are ongoing in the courts. And we have endeavored to give them some access for the video hearings, but it's limited, as I say, because of the bandwidths and some other practical problems that we have. But we are relying to a considerable extent on the media to follow us on our website to try and communicate what we are doing with various challenges we're facing. And I'll say one more thing, and that is the requirements of the criminal code, which affects some of what we can and can't do. And because they're in the federal domain, we would have to approach the federal government for changes in the requirements that exist in the criminal code. And I would think they would want to have input from all provinces before they were to contemplate any changes to the code or any federal legislation. So that's less likely to happen quickly. I hope that answers your questions.
Yes, thank you so much, Chief Justice Hinkson. And our next question is around urgent motions. Many motions have been adjourned because they don't reach a threshold of urgency. However, as time goes on and parties' incomes are impacted by COVID-19, do you think that a motion that was not urgent to a party may suddenly become very urgent? And I think with that question, we'll go back to Chief Justice Bauman for the first response, please.
Absolutely. Legal problems that aren't addressed, we understand how they fester and become more serious. as time goes on. The fact is, we initially tried to restrict it to urgent matters in a reaction to the immediacy of the crisis. But as you know, we're going, as of May 4, back to a normal chambers list in which urgent and non-urgent matters are heard. But during this entire period, our court's been available, if necessary, to hear anything, anytime, in various ways, whatever way is necessary. And I hope that no urgent or no application that has become urgent was left unheard during that period. But as I say, hopefully we'll be back to quote normal on Monday, May 4, and continue through in that fashion to deal with all applications.
Thank you. And the same question to Chief Justice Hinkson, please.
Our experience to date with requests for urgent hearings has been that about 60% of them have been permitted by duty judges who are doing initial vetting. We've not been giving reasons for either allowing or disallowing requests for urgent hearings. And I don't think that's going to change. But as you point out, some matters that weren't urgent when the application was made may become so. And those individuals can renew their application for urgent status, or they can try and use one of the other means that we've been developing, telephone conferencing or written submissions, to have their matters heard. We are trying to move as quickly as we can to providing the opportunity for those who need their problems sorted out in the courts to do so, and we'll continue to do so. And as I mentioned earlier, I think with the telephone conferencing and the written submissions, we're starting small. I know there's some concern over, for example, the number of pages that we're allowing for filing purposes. With the telephone material, it's been limited, for example, to affidavits of no longer than 10 pages, with including exhibits. We find in our experience in our court that we are often buried with paper that is unnecessary for us to resolve an issue. So we're depending on the bar to try and limit what they feel they need to say in order to get urgent and even non-urgent matters resolved before us. And we'll continue to do that. But as I say, we hope to expand what we're doing beyond single issues, which may enable litigants to get a complete answer to some of their problems. And for those matters that we're persuaded are urgent, we may even conduct full hearings